to welcome everyone to the fourth meeting of the Senate Standing Committee on Families and Children. I would ask that everyone to please silence their phone, and Madam Secretary, if you would please call the roll.
Senator Chambers Armstrong. Here. Senator Elkins.
Present.
Senator Girdler. Here. Senator Mays Bledsoe. Present. Senator Meredith. Present. Senator Tishner. Senator Webb. Senator Westerfield.
Here.
Sorry. Senator Wise.
Present.
Vice Chair Rocky Adams. Here. Chairman Carroll.
Here, we do have a quorum and are duly authorized to conduct business. We have two bills on the agenda today, Senate Bill 145 and Senate Bill 151, both sponsored by Vice Chair Senator Julie Rocky Adams. Senator, if you would please proceed to the table. And do you have a guest on 145? Okay. Okay, we'll start with 145, and this is an act relating to health care. If you would please introduce yourself for the record, and you have the floor.
Thank you, Mr. Chairman, and thank you, committee, for entertaining Senate Bill 145 this morning. So Senate Bill 145 is really a very common sense public protection measure that's being proposed to establish the statutory framework allowing healthcare facilities and providers enrolled in Kentucky's Medicaid program to submit current and prospective employees to a check of the Child Abuse and Neglect Registry and Adult Abuse Registry within the Cabinet for Health and Family Services. So existing law already requires that schools, church volunteers, child care providers, nursing homes, and others to check at least one of these registries. However, our current statutory framework does not allow for other healthcare facilities such as hospitals, chemical dependency providers, ambulatory surgery centers, community mental health centers, ambulance providers, dentists, and others to check these registries. So this bill just proposes to close that gap. In crafting this bill, I wanted to be mindful and sensitive to the unintended consequences that government mandates can have on the entities imposed in this bill. So therefore, this bill before you establishes these registry checks on a voluntary basis. No provider groups or health facility is required to complete these checks under this bill. But this bill does not impact any other groups or healthcare providers that are already required to conduct child abuse and neglect registry or adult abuse registry checks. It simply establishes the statutory framework allowing all healthcare facilities and Medicaid providers to conduct these registry checks on current and prospective employees. So I want to be clear, and I trust and sincerely hope that our healthcare providers will conduct these registry checks, because intent is to provide them with another tool to ensure that our most vulnerable are receiving high quality care in the safest environment. So I also want to point out that in subsection 2 of this bill, it requires the cabinet to promulgate administrative regulations as necessary to implement these registry checks. So the cabinet will be able to define any fees and timeframes for receiving and processing these checks through their administrative regs. I sit on the Administrative Regs Review Committee, and I will be monitoring these regulations closely to make sure that the process is efficient and effective. So I thank you for your consideration, and I'm glad to answer any questions. And I know that we have a sub before us.
We do, and you want to explain the sub, or did you cover that in your...
If I may I defer to Senator Westerfield, as he was the one that wanted to add the change to the sub.
Senator Westerfield, please proceed.
Thank you, Chairman. Thank you, Senator. I appreciate that. And I appreciate your support of the sub. The sub makes one change. It was brought to my attention just a couple weeks ago that because these abuse registries have been around for a long time. I think the last one we created was the Adult Abuse Registry, sponsored by then Senator Sarah Beth Gregory about a decade ago. It's been brought to my attention that when there's been a substantiation of some claim, your name goes on the registry, as soon as that person files an appeal, their name effectively comes off the registry, so to speak, because the statute simply says, is there a claim or isn't there? The sub requires the cabinet, when asked, yes, there's a claim, no, there's not a claim, or there's an appeal pending. So that there's not some silence that looks like there's no claim at all. We want to make sure people know that while there was a claim, there's an appeal pending. That's what the sub changes.
So will that change the structure of how they post on those checks?
No, because of course it's at least on the adult abuse registry. I can't speak about all the rest of them, but there's not like a list that's publicized. It's just a list that the cabinet internally keeps, and when asked, they respond, yes, they're on the list, or no, they're not. Okay. This adds a third answer.
Okay.
Instead of yes, they're on the list, or no, they're not on the list, the third answer is there's an appeal pending about whether or not they're going to be on the list.
Okay. Any other questions on this? Have a motion on the sub. Have a motion and a second. All those in favor, please signify by saying aye.
Aye.
Opposed, no. Motion carries. I have a motion on Senate Bill 145 as amended by PSS 1. Have a motion, have a second. Madam Secretary, please call the roll.
Senator Rocky Adams.
Aye.
Senator Chambers Armstrong. Aye. Senator Elkins.
Aye.
Senator Girdler. Aye. Senator Mays Bledsoe. Aye. Senator Meredith. Aye. Senator Tishner. Senator Webb. Senator Westerfield. Aye. Senator Wise. Aye. Chairman Carroll.
On a vote of 10-0, Senate Bill 145 as amended by PSS 1 passes with favorable expression. Congratulations, Senator. And if you would please proceed to Senate Bill 151, and I think you have a guest joining you at the table.
Yes.
Ms. Hatfield. If both of you would, please introduce yourselves for the record, and you have the.
And then you just want to go after me? Yeah, okay. All right. Again, I'm Julie Rocky Adams, Senate District 36.
And I'm Norma Hatfield. I'm president of the Kinship Families Coalition of Kentucky, and I'm a grandmother who's been raising 2 grandkids for the past 9.5 years.
Okay, so before us is Senate Bill 151, and this has been developed to address issues and concerns being raised by our relative and fictive kin caregivers. So some of you may recall that in the spring of 2019, Kentucky began offering relative foster care options, which was designed to provide financial assistance similar to traditional foster care. The Department for Community-Based Services and the courts have established a policy that there is a one-time only, that's really key, one-time only decision for a relative or fictive kin caregiver to accept a temporary custody for a relative foster care placement for a child who is in need. So it has come to my attention that this policy is very restrictive, and it is putting a financial and resource strain on many of our relative and fictive kin caregivers. So let's take a moment to think through how a relative placement plays out. So imagine Child Protective Services contacting you to see if you were willing to care for a child in your own family, a niece or a nephew or a cousin, who is at risk of being abused or neglected. Most of us would step up. This is the very same moment you are being presented with the placement options available to you. So number one, you can either accept temporary custody of the child, which has minimal supports and resources available. Or 2, you can deny accepting the child, and then they go into a traditional foster care placement. As we all know, that this is very disruptive, and it takes the child away from that family structure. Or you can accept a relative placement option, which comes with additional supports such as daily per diem, stipends for clothing, training, respite care, or even potential permanent custody after 6 months. Remember that you are making this one-time only decision on the spot with no ability to reassess or fully understand the impact that your decision will have on your personal finances. So the reality in all of this is that, unfortunate as it may be, a child needs to be removed from a parent. Our families in Kentucky want to step in and help their own. There is no doubt that our relative and fictive kin caregivers are making this one-time decision in real time under duress for a child in their family who is at risk of being harmed, abused, or neglected. So as many of our relative caregivers take on the additional responsibilities of caring for a child in their care through temporary custody, their financial situations may change. And there is confusion and inconsistent responses provided by DCBS on how to address it. So therefore, you have 151 in front of you so that our relative and fictive kin caregivers can have that flexibility in how they are able to attain additional assistance and supports for care of the children that are placed in their homes. The intent of 151 is to incorporate that flexibility into relative and fictive kin placement options by allowing our caregivers the opportunity to change their placement status from temporary custody to a child-specific foster home as necessary. This flexibility will close the services, supports, and resources gaps that is currently plaguing many of our families. So Senate Bill 151 has 3 sections. Section 1 creates the definition of a child-specific foster home. And this means an individual or family approved by the cabinet as a foster family home for a relative or fictive kin placement. Section 2 of the bill was included in this proposal due to the feedback I received from former foster youth who are seeking to elevate their voice in placement options to require the court to consider potential relative or fictive kin caregivers from a list that's provided by the child, and who will be removed from their home if they are able to or by the child who will be removed from their home if they are able to provide such a list. And then Section 3 allows a relative or fictive kin caregiver to apply to the cabinet as a child-specific foster home for a child who is currently or may be placed with him or her. And this section also requires the cabinet to seek any state or federal waivers that they may need in order to implement this provision of the bill. So I also want to point out that the existing in Section 3 of this bill requires that the cabinet promulgate administrative regs to further implement this placement option. So the cabinet will be charged with collaborating with the various advocates, stakeholders who will inform them on how best to develop these regulations, such as current and former foster youth, relative and fictive kin caregivers, and judges. So again, I'm on the regs committee, so I'm going to be watching this like a hawk. And I also want to share that a fiscal note has been released. It should be in your packets. And I will share with you the fiscal note. I don't have my glasses with me, but it says this legislation should have no additional fiscal impact to the Cabinet for Health and Family Services, and also there's no anticipated fiscal impact to the Justice and Public Safety Cabinet or Administrative Office of the Courts. So thank you, and then I think Norma has a few comments to share with the committee.
Thank you. I'm asking for your support of this bill. There are a lot of reasons, a lot of families that have issues with the way this program is implemented right now. If you look at a DCBS report that they issued in September 2023, more than half of the children are in temporary custody instead of relative foster care. That in itself indicates there's an issue there, because we've heard for years and years and years, I've come to this table many, many times, and caregivers need more assistance for their kids that they care for. And this is a huge one right here, the relative foster care option. I wanted to share a story with you about one of the very first grandmothers that reached out to me when this program in 2019 rolled out. Her name was Margie. And she actually tracked me down. I was speaking on kinship care at a church, and she said, here's what happened. She said, here I am. I'm approached by a social worker. She tells me my grandson's just been removed because there were drugs in the home, and my head is spinning. And she said, I'm overwhelmed emotionally by this. I'm overwhelmed by the fact that there's this social worker standing here in front of me. What's going to happen to my grandson? All of these things are going through my head. Is he okay? And then the social worker tells her basically, well, you can take him in temporary custody, or he can go under custody of DCBS, and all she hears is in foster care. Custody, DCBS, foster care. Now, this is not the best time to make a life-altering, permanent decision. And what she did was she said, of course I will take him. Where do I sign? And she's checked the box, temporary custody. Later, she realized, after she saw things in the news about this program, she found out that she actually could have some additional assistance for her grandson. And when she went back to DCBS, they said, you checked the box, it's done. And I said, wait a minute here. That doesn't sound like a very good scenario. Why are we making life-altering decisions, permanent decisions, under a time of duress? And you think about Margie's situation. What about the grandma who gets called to the hospital because, a little baby, her grandchild, has a brain bleed and is in ICU? That's not a good time to make decisions. And there are all different scenarios that are out there. And I actually went to a senior, very, very senior person in DCBS when I did an ombudsman complaint for Margie. And I said, this is what's going on. I'm hearing this not only from this grandmother, I'm hearing it from others as well. You guys need, would you consider changing your policy? And the answer was, well, we can do better in communicating to our field offices, but this is legal, and they slid the form back across the table. Now, that is not how we need to treat people. That's just not right. And I'm going to tell you, this has been going on for years. We've had, actually a couple months ago, some folks from Kentucky Youth Advocates and myself, we were on a Zoom call, and a grandmother whose grandchild was also born addicted to substances had this just happen to her this past year, or 2023. So this is still going on. Now, there are a couple of things that I want to talk about on why we need the bill. One is Margie's situation and grandparents like her. Another one is sometimes financial situations change. When you have a two-income house, two grandparents working as an example, and I happen to know this happened to one particular grandmother named Teresa. Her grandchild was born with a lot of different substances in her little body, and she had to quit her job because the baby required 24/7 care for a long time. Sometimes it's a lifetime. So while temporary custody might be okay at first, while that case is open, financially things happen, life happens, and she should have the option to switch to something that gives that child the things that they need. And then the last one is, in general, a lot of caregivers just don't trust DCBS. Now, I've had these conversations with them. They're aware of it. They're working on that. But all they hear is you can have temporary custody, and they think that somehow DCBS is not as involved, even though they need the resources, and they don't make the best decisions that they could with all the right information. We have a very rigid, inflexible system when we talk about the child welfare system. And for all the good things that it does, it is very rigid. It doesn't take into account sometimes errors in bureaucracy, errors in communication, or giving or receiving the communication, or just life. And if you approve Bill 151, which I'm asking you, pleading with you to do, we're going to add a little more humaneness in a world for kinship caregivers that are having to deal with a lot of tough things and help these kids.
Thank you. And we're open to any questions. I'll take the easy ones, and Norma will take the hard ones.
I have a couple. So with this child-specific foster home provider, the time frame, because I know to become a foster parent, that takes a while, and it's a pretty in-depth process. What happens during that time frame, or is it an abbreviated type process, or what happens to the child during that time frame if it's at the beginning?
And I think that some of that will be worked out on the regulatory side, but from what I understand, our ultimate goal is to keep these kids with someone that's in their family. And so I believe that it allows them to keep the child in the home and then go through the processes that are required to be qualified as a foster parent.
Okay. And then the second question, and I know with foster kids, there are restrictions that a foster parent has on what they can do with that child, who they stay with. Will those be the same if it's? I mean, if the child is at an aunt, uncle, grandparent, how do those restrictions apply in those circumstances?
Yeah, and I can't answer that specifically, but I do think that in order to qualify, we are going to have to follow whatever the federal guidelines are and the state guidelines. And so I'm assuming that will be spelled out pretty specifically in the establishment of this entity.
And I don't know exactly what those restrictions are. I've just
Yeah.
heard like who they can stay with or traveling out of state, things like that could be
Right.
kind of awkward if they're staying with their grandparent.
Right.
And that may be something in the future that we might want to take a look at
Yeah.
to loosen some of those restrictions.
Yeah.
So the child could live a more normal life. And I could see that getting a foster grandmother in trouble, aunt, uncle, if they didn't follow those, and
Yeah.
Common family event that could end up violating regulations.
Yeah. Unintended. Yeah.
Yes. Any other questions? We have a motion on the bill. Have a motion and a second. Madam Secretary, please call the roll.
Senator Rocky Adams.
Aye.
Senator Chambers Armstrong. Senator Elkins. Senator Girdler. Senator Mays Bledsoe. Senator Meredith.
I'll explain my vote, please.
Please proceed.
I vote aye. I just want to thank you both for bringing this bill. And I've had a lot of conversation with Ms. Hatfield about this, and this is a long time in coming. It certainly is a sad commentary on society when we've got to take these kind of measures, and certainly family members deserve the same kind of support that foster parents do, and we commend our foster parents, but I think this is really going to elevate our state. I think there are some details that are going to have to be worked out, as Senator Carroll has mentioned, but this is a good step forward, and particularly Ms. Hatfield, I appreciate your hard work, diligence, and commitment to this, and I've been in the Senate 8 years, and you've been here every year advocating for this, and I commend you. Thank you.
Senator Tishner. Senator Webb. Senator Westerfield. Senator Wise.
Aye.
Chairman Carroll.
Aye. Vote of 10-0. Senate Bill 151 passes with favorable expression. Senator Rocky Adams, you are batting 1,000 today. Congratulations.
I'm quitting while I'm ahead. Thank you.
And thank you both. Ms. Hatfield, thank you for all your advocacy. Okay, that is the last item on the agenda. Right now, we do not have any other bills assigned to this committee. Hopefully, we will this week for our meeting next week. And we will, Senator Funky Fromeyer has a bill that's going to be coming back through that she is getting a committee sub, the details worked out on that, and we will hear that next week also. If there is nothing else, I'll entertain a motion to adjourn.